Good morning, good afternoon, good evening. Thank you for joining us. This is the second panel presentation in a series on incidental proceedings sponsored by the International Courts and Tribunals Interest Group. I'd like to thank the interest group leadership and the several members who have volunteered to put together the series, ASIL for hosting and providing today's technical support, and all of the distinguished speakers who have joined us for the series, including today's participants, who I will introduce momentarily. Our first panel in September 2024 looked at provisional measures. The third, forthcoming panel will focus on interventions. The subject of today's panel is preliminary objections, one of the most common types of incidental proceedings before international courts and tribunals. In the succinct words of the ICJ in the Barcelona traction case, the object of a preliminary objection is to avoid not merely a decision on, but even any discussion of the merits. According to Professor D'Argent, respondent states have a fundamental procedural right not to have to explain their impugned conduct before a court they consider lacking jurisdiction or being improperly seized. Therefore, it is unlikely that raising preliminary objections will ever be considered by the court as being abusive. Given this latitude, Hugh Thorway has observed that the ingenuity of pleaders has caused preliminary objection to take so many different forms that it is difficult to define it other than by its effects. In addition to the primary goal of dispensing with the merits altogether, creative international lawyers might use preliminary objections to pursue more tactical goals by favorably shaping the factual record before the court, defining the parties' relationship with the court, pre-litigating the merits of the dispute, controlling the length and pace of the proceeding, or raising the salience of highly contentious or political issues by forcing a preliminary decision from the court into the court of public opinion. Especially skilled international lawyers will wield compromissory clauses and jurisdictional constraints to disaggregate disputes, to funnel them toward or away from or across different international courts and tribunals. Preliminary objections are thus not only a matter of right, but a useful tool in the international lawyer's toolkit. Today's discussion will delve into the topic deeper by considering the benefits and drawbacks of disaggregation, the distinction between jurisdiction and admissibility, the use of compromissory clauses in treaties to bring specific aspects of dispute within the jurisdiction of different courts and tribunals, and how regional human rights courts have addressed the disaggregation of disputes. We are fortunate to have a distinguished panel of speakers to assist us in that task. I will introduce them in the order of their presentations. Lawrence Hill Cawthorne is Professor of Public International Law at the University of Bristol in the United Kingdom. His research interests cut across a number of topics, with recent work focusing on international dispute settlement, international humanitarian law, international human rights law, and international criminal law. His monograph, Detention in Non-International Armed Conflict, was awarded ASIL's 2016 Francis Lieber Prize for Best Book in the field of international law and armed conflict. Callista Harris is a barrister at 7 Wentworth Selborne Chambers in Sydney and an associate member of 3 Verulam buildings in London. She specializes in public international law disputes, including before the ICJ and UNCLOS tribunals. Her main area of academic research is the scope of jurisdiction and proceedings brought before international courts and tribunals pursuant to compromissory clauses. Raphael Wren is a partner at the Lim Chi Wee Partnership, specializing in commercial litigation and arbitration. He regularly appears as counsel in the superior courts of Malaysia and assists senior counsel from England and Singapore on complex multi-jurisdictional disputes adjudicated outside Malaysia. His articles on international arbitration have been published widely. Notably, he posited a contrarian critique to the transposition of the concept of admissibility from public international law to international arbitration in the recently published article, The Dichotomy Between Jurisdiction and Admissibility in International Arbitration, which appeared in the International and Comparative Law Quarterly. Last but not least, Professor Claudia Martin is the co-director of the Academy on Human Rights and Humanitarian Law and professorial lecturer in residence at American University, Washington College of Law in Washington, D.C. Claudia specializes in international law, international and comparative human rights law, and inter-American human rights law. She is also a founding member of GQUAL, a campaign to promote gender parity representation in international courts and organs. Additionally, she has submitted several amicus and expert briefs before international and domestic courts to ensure justice for victims of sexual and gender-based violence in Latin America. At the conclusion of all the presentations, we expect sufficient time to field questions for the panelists, so I encourage attendees to put their proposed questions in the Q&A, which will be reviewed and presented then to the panelists. So thank you all for being here. Without further ado, I turn the floor over to Lawrence.
Hi there, everyone. Thanks, Craig. I hope you can hear me clearly. So just to reiterate Craig's introductory point, that the kind of scenario we have in mind here are where particular legal claims are brought before an international court or tribunal concerning a treaty provision, or at least ostensibly concerning a treaty provision over which that court or tribunal has jurisdiction, but where adjudicating on that legal claim will implicate in some way either a much broader background dispute within which this particular claim falls, or indeed other specific legal rules that exist outside the particular treaty over which the tribunal has jurisdiction. What I have been asked to talk a little bit about are the ways in which an applicant state in proceedings could respond to challenges to the jurisdiction of a tribunal in these kinds of cases, and the benefits and risks with the kinds of arguments that can be raised here. So it's very common at the preliminary objection stage to challenge the jurisdiction of different international courts and tribunals on the basis that the application somehow mischaracterizes the true dispute, right? So on the basis that somehow the legal claims that appear before the court do not really represent the true issue, the true subject matter of the dispute. And it's sometimes even suggested that this reflects an abusive process, that they're trying to circumvent the lack of jurisdiction over the true dispute and just trying to kind of squeeze it or shoehorn it into the particular treaty provision over which the tribunal does have jurisdiction. So it's very common before lots of different international courts and tribunals. This point is made by respondent states. Just a couple of examples: in the ongoing case between Iran and the United States regarding the 1955 Treaty of Amity, one of the US's preliminary objections was precisely on the argument that Iran's claims under that 1955 treaty misrepresented what was really the true dispute, which, according to the US, was a dispute over its withdrawal from the Joint Comprehensive Plan of Action, the Iran nuclear deal. So in the US's words, and I quote, "The true subject matter of this case is a dispute as to the application of the Joint Comprehensive Plan, an instrument entirely distinct from the Treaty of Amity, with no relationship thereto. A compromissory clause through which the parties consent to the court's jurisdiction in respect of disputes about the interpretation and application of one instrument cannot accord jurisdiction in respect of disputes over the application of another instrument. Iran's endeavor to bring to the court this Joint Comprehensive Plan dispute under the compromissory clause of the 1955 treaty also amounts to an abusive process." And we see that kind of challenge to jurisdiction arising time and again. It's a very common preliminary objection by respondents in these kinds of cases, which we can think of as being cases where a broader dispute, or a dispute that has lots of aspects to it, is sort of disaggregated and litigated on just one specific legal claim. Now, a common response by applicants, and one that is often very effective, is precisely this idea that it is possible and perfectly legitimate to disaggregate disputes in this way, that even if there's some larger background dispute, even if extraneous legal rules are implicated, the fact that there's an arguable case that the particular rules over which the tribunal has jurisdiction are engaged is sufficient for that tribunal to exercise jurisdiction. And that has been a very effective counter-argument to the kinds of preliminary objections that I just highlighted, like that preliminary objection by the US in the Iran-US case. The ICJ itself has been especially willing to accept this kind of argument. So the International Court of Justice hasn't tended to inquire too deeply into what is thought to be the real subject matter or character of the dispute. It hasn't tended to do that. Its approach has, for the most part, been to say, well, as long as there's an arguable case on the merits, that rules over which we have jurisdiction are engaged by the alleged acts of the respondent state, then that's sufficient for us to exercise jurisdiction. It doesn't matter that there's some broader dispute in play. So we could see this response by the ICJ to the US's preliminary objections in that Iran-US case on the Treaty of Amity. And again, just briefly, I can quote from their preliminary objections judgment. The fact that the dispute between the parties has arisen in connection with and in the context of the decision of the United States to withdraw from the Joint Comprehensive Plan of Action does not in itself preclude the dispute from relating to the interpretation or application of the Treaty of Amity. Certain acts may fall within the ambit of more than one instrument, and a dispute relating to those acts may relate to the interpretation or application of more than one treaty or other instrument. So this is a really common approach for the ICJ to take here. And in that sense, it can be quite an effective response to this kind of preliminary objection to simply say, it doesn't matter that there's some broader dispute in play here. It doesn't matter that there's extraneous rules that are equally as applicable. We're just focusing our claim on this particular treaty over which the tribunal has jurisdiction. That's been a relatively consistent approach of the ICJ. Now, of course, that argument only works, that argument of the applicant only works if the tribunal does follow that same approach, where it's not too concerned with trying to characterize the dispute. What I want to do, though, is outline a few risks now where actually this kind of strategy might be problematic. And there's two kind of scenarios I want to think about. One, perhaps the more obvious one, is where the tribunal is less willing than the ICJ in these cases, for example, to sort of ignore the general character of a dispute, is less willing to put that to one side and actually wants to try to identify what the character of the dispute is or the subject matter of the dispute. And we've seen that in the context of UNCLOS litigation. That's the first problem that can arise here. The second problem is, even in those cases where the court, such as the ICJ, says, you know, we're not too interested in whether there's a broader dispute here. We're not worried about incidental issues. Even in those cases, there are still risks with this particular litigation strategy, and those risks can arise both at the merit stage and at the preliminary objection stage. So I'll take both of those in turn. The first one is this point about what happens where we have a tribunal that does want to make a deeper inquiry into the character of the dispute. And this has been, of course, a feature of UNCLOS cases where Annex 7 tribunals have placed much more weight on the character or subject matter of the dispute. And in so doing, they have, on occasion, rejected the application and held that we don't have jurisdiction over the application precisely because it implicates these extraneous legal issues. And it's particularly the case, or rather I should say specifically the case, where an UNCLOS tribunal is dealing with a sovereignty dispute. An UNCLOS claim that sits within a broader sovereignty dispute. Of course, the Chagos Annex 7 tribunal is the classic example here, where the tribunal said, you know, we think the real dispute here is not actually some UNCLOS claims. The real dispute is really a sovereignty dispute over the Chagos archipelago, a dispute between Mauritius and the UK. And we simply can't rule on the UNCLOS claims without also taking a position on the sovereignty dispute. And so because of that, the arbitral tribunal said, we don't have jurisdiction over that aspect of the particular claims. We can't rule on these particular coastal state rights, because to do that requires us to examine this sovereignty dispute. And their approach was very much to say, well, the true character of the dispute, the relative weight of the dispute very much is about sovereignty rather than unclause. So in contrast, the ICJ, that, as I said, isn't too concerned with the character, the Annex 7 tribunal in Chagos was concerned about that. So that's a good example where this kind of argument will fail, this kind of argument such as that which Mauritius made in that case, that yes, there's a sovereignty dispute, but nonetheless, our case is just about unclause. The tribunal may not buy that argument and might be unwilling to exercise jurisdiction. This risk, though, actually can go further. It might not just be that the tribunal says we don't have jurisdiction. It might even go one step further and actually say something about the sovereignty dispute, and something that the applicant absolutely does not want it to say. And this is precisely what we saw in the more recent coastal state rights Annex 7 award. So this, of course, was the dispute between Ukraine and Russia in relation to coastal state rights around the Crimean Peninsula. Russia there raised typical preliminary objection, said this dispute is really about aggression, it's about sovereignty. It invoked the Chagos case as authority for the fact that tribunals can't exercise jurisdiction over an unclosed dispute if actually the relative weight of the dispute rests with sovereignty. So Russia made this very classic argument. It said you can't drive a jurisdictional wedge between the sovereignty issue and the unclosed claims. They're all part of the same thing, and so the tribunal isn't allowed to exercise jurisdiction at all. Ukraine's strategy in that case was a slightly risky one, and the risk, in fact, materialized. And it was risky because Ukraine knew, based on the Chagos case, that the tribunal was likely to say, yes, we do need to kind of consider sovereignty here. We know that's an issue we have to predetermine. But for Ukraine, they said, it's not a dispute. There's no sovereignty dispute. Russia is simply raising this claim to be sovereign of Crimea just for the purposes of this case in order to try to preclude the tribunal from exercising jurisdiction. The arbitral tribunal, unfortunately for Ukraine, said, we do have to think about sovereignty of Crimea to address this claim. We don't have jurisdiction over that. And they went one step further and said there is actually a genuine sovereignty dispute between these two states over Crimea. It is not one that has just been invented by Russia in this case. We can see that it predated this particular case. That's a real risk. As you can see, that can materialize with these kinds of cases, right? That the tribunal will not just say, we can't rule on the principal claim because it implicates these extraneous rules. It will go further and actually say something that the applicant absolutely does not want it to say. In fact, in this case, Ukraine very much wanted the tribunal to say there is no sovereignty dispute. It's not in doubt that Ukraine is sovereignty. The tribunal said exactly the opposite. So that's a real risk that goes with these kinds of disaggregated claims. Craig, I know I'm sort of running close to the end of time here, not literally, but at least for me. So I will try to finish up relatively swiftly. But what I want to do just for the final part is talk a bit about the risks that come not from the tribunal rejecting jurisdiction. That's what we just covered, the Chagos case, the coastal right states case. What I want to talk about is where there are risks that come even when the tribunal agrees with the applicant state that the dispute can be disaggregated. And we see this in a number of ICJ cases where although the ICJ has agreed with the applicant state that it's perfectly reasonable to litigate one particular aspect of a dispute, even when it relates to another dispute over which the ICJ does not have jurisdiction. The ICJ said it's absolutely fine to do that, but we then see problems arising when the court starts looking at the particular claims made specifically. So to give an example, in the Ukraine-Russia case involving the application of the Convention on the Elimination of Racial Discrimination and the International Convention on the Suppression of the Financing of Terrorism. This was, of course, one of those early interstate cases brought by Ukraine against Russia in relation to the annexation of Crimea and support for separatists in eastern Ukraine. Again, Russia raised a preliminary objection early in that case, said this dispute is not at all about CERD, the Convention on the Elimination of Racial Discrimination, nor is it about the Suppression of the Financing of Terrorism Convention. It's really a case all about use of force, about support for rebels, about annexation of territory. Now, the ICJ rejected that and said, no, we can rule on this. It's just about CERD. It's just about the Convention for the Suppression of the Financing of Terrorism. So at the preliminary objections phase, Ukraine was successful. But we know at the merits phase, just last year, Ukraine, excuse me, lost on many of the points. And it lost on many of the points, partly because those two treaties had really been untested before. Those two treaties had not been examined at the merit stage in any ICJ litigation before. So one of the real risks that arises in this kind of litigation strategy is if you're relying on compromissory clauses in treaties that have thus far been untested before the particular court. We might say, well, that's just a typical risk. It doesn't matter. But of course, Russia has then relied on that merits judgment as propaganda. So we can see when that merits judgment came out last year, the Ministry of Foreign Affairs in Russia released a statement, very much holding it up as a kind of success for Russia. And in the statement, the MFA said, and I quote, Russia's arguments undercutting Ukraine's groundless insinuations were heard in The Hague. The court rejected almost all of more than 20 submissions made by Kyiv during the 7-year proceedings and left Ukraine without any reparations. The ICJ did not follow Kyiv's lead and refused in principle to recognize Russia as an aggressor state. Now, of course, that does rather misrepresent what the court actually said, but nonetheless, you can see how it's being used as propaganda. So again, it's a risk that states run with this litigation strategy. Final example here, and then I'll stop. Again, if the treaty that you're relying on to bring your claim, if it's not a particularly persuasive argument on the merits, we might even see that kind of concern seeping into the preliminary objections phase itself. So not just at the merit stage, we might even see the court reviewing that at the preliminary objections phase. And that's exactly what we saw with the ICJ's allegations of genocide case and the preliminary objections judgment there. Of course, this is the other Ukraine-Russia interstate case brought in the light of Russia's full-scale invasion in February 2022, brought on the basis of the Genocide Convention. I think most people will be familiar with the facts, so I won't go into it. Again, Russia said the real issue in this case lies outside UNCLOS. The real issue in this case is about an alleged wrongful use of force in violation of the UN Charter. Ukraine responded, said, no, this is purely about the Genocide Convention. All we are asking you to do is review the extent to which Russia has complied with Articles 1 and 4 of the Genocide Convention. Now, the court agreed. The court agreed that all Ukraine was asking for was for it to rule on compliance with Articles 1 and 4 of the Genocide Convention. It was very brief on characterization or subject matter of the dispute. But as part of Russia's more specific ratione materiae objection in that case, it said there's no real argument that the Genocide Convention prohibits what Ukraine is alleging Russia has done. So it actually really did rather intrude onto the merits of the claims at the preliminary objections phase. And indeed, this was one of the criticisms of Judge Charlesworth in her separate opinion in that case, that actually the court was treading a little too much into the merits. Again, that judgment, that decision has been invoked as propaganda by the Ministry of Foreign Affairs in Russia. Again, I'll just briefly quote, shortly after that judgment came out, the MFA said, even at that preliminary stage, the case concocted by Ukraine has already fallen apart. The court totally rejected all Ukraine's claims that Russia has violated and abused the convention to justify starting its special military operation. The court accepted Russia's preliminary objections and agreed that Kyiv's accusations have nothing to do with the convention. So again, a good example of how certain risks come from this kind of litigation strategy, particularly if the arguments on the merits are either untested or actually just rather weak in themselves. And I'll leave it there because I know I've overrun.
Thank you very much, Lawrence, for those insightful remarks and for setting the scene for the rest of our discussion. Before I turn the floor over to Callista, we'd just like to remind our participants to use the Q&A box to pose questions for the panelists at the conclusion of their presentations. So Callista, the floor is yours.
Thanks very much, Craig, and thank you to the interest group for inviting me to participate in this session today. As the title of my presentation suggests, my research focuses on the scope of the jurisdiction that is conferred on international courts and tribunals under compromissory clauses. And I expect that most people on the call will be familiar with compromissory clauses, but for those who are not, just to clarify, compromissory clauses are the clauses that you find in treaties such as the ones Lawrence has mentioned, UNCLOS, the Genocide Convention, other treaties, in which states agree to have disputes concerning the interpretation or application of that particular treaty referred to judicial settlement. So the key point to note in these clauses is that they are limited to a specific category of disputes, being disputes concerning the interpretation or application of the particular treaty. So from my perspective, the challenge or problem with these clauses is that it's not entirely clear or resolved what that language, a dispute concerning the interpretation or application of the treaty, actually means. There are different interpretations of that phrase between different courts and tribunals. There are different approaches to the meaning of that phrase, even within one court, such as the ICJ, in its different decisions. And even in some decisions, you get different approaches by different judges or different arbitrators in the very same case. So why does this problem matter, and how does it arise in practice, this issue of the lack of clarity of the meaning of these clauses? The meaning of compromissory clauses matters, of course, because of the consensual nature of international dispute settlement. International courts and tribunals do not have plenary jurisdiction. They only have jurisdiction to the extent that the parties have conferred that jurisdiction on them. And in practice, sometimes the only way to bring a dispute before an international court or tribunal is by invoking one of these compromissory clauses. And when a state relies on one of these clauses, almost invariably, there is a fight between the parties regarding whether the dispute does or does not fall within the scope of the tribunal's jurisdiction under that clause. And one particular and interesting aspect of the problem, which Lawrence has already mentioned, concerns the situation where a dispute is brought before a court or tribunal pursuant to a compromissory clause, and the dispute involves not only issues under the rules in the relevant treaty, but also involves issues under rules found outside the treaty, which I'll refer to as external rules. So I'm particularly concerned with this situation, not the situation Lawrence mentioned where the dispute is part of a broader dispute, but the specific situation where the dispute involves issues under external rules, as well as under the rules in the relevant treaty. And in addition to the examples that Lawrence mentioned, including situations where you have UNCLOS proceedings where issues of sovereignty are raised, some other examples you might be familiar with where this type of situation has arisen is in the other set of proceedings before the ICJ between Iran and the United States, the certain Iranian assets proceedings, which were also brought under the 1955 treaty that Lawrence mentioned. And those proceedings raised issues of immunity And another example that you might be familiar with is the ICAO proceedings before the ICJ involving Qatar and other Arab states, which were brought under the Chicago Conventions, but also raised issues by way of countermeasures in relation to permissible countermeasures. And in relation to all of these cases, the general question is, can the court or tribunal, exercising jurisdiction pursuant to a compromissory clause, decide the dispute that has been brought before the court, this dispute involving issues under external rules? And if courts and tribunals can make determinations under external rules, in exactly what circumstances can they do that? And I think my presentation dovetails quite nicely with Lawrence's in that I think it's fair to say I argue for quite a broad interpretation, or a broader interpretation than others, of compromissory clauses. And so the argument I advance is really a way for applicants to attempt to overcome or address some of the risks that Lawrence has identified in his presentation. So for the remainder of my time, I'll give an overview of my answer to this question that I've raised. So I think at the outset, one fundamental point that it's important to keep clear is the distinction between jurisdiction and applicable law, which I think leads to a lot of confusion in these cases. So jurisdiction concerns the disputes that a court or tribunal can decide with final and binding force. Applicable law, in contrast, concerns the rules of international law that the court or tribunal can apply in ruling on those disputes. So in simple terms, jurisdiction concerns the disputes a court can rule on, and applicable law concerns the rules the court can apply in deciding those disputes. And so when a dispute is brought before an international court or tribunal pursuant to a compromissory clause, the first question for the court or tribunal to determine will be, does it have jurisdiction over the dispute? And what I argue in my writing is that a court or tribunal should approach this question by looking at the specific claims that are made before it. So by looking at the claims that the claimant asks the court or tribunal to adjudicate or rule on, which are opposed by the respondent. And this view that you need to focus on the claims that are opposed between the parties, this view is really based on the traditional understanding or definition of what a dispute is from cases such as Mavromatis and the Southwest Africa cases. And I argue that a court or tribunal should not determine its jurisdiction by first engaging in the process that Lawrence has mentioned, where courts and tribunals sometimes characterize the real subject matter, or the court's perception of the real subject matter of the dispute between the parties. In my view, that's not an analytically sound approach. But in a number of recent decisions, as Lawrence mentioned, this approach has been used by UNCLOS tribunals. And I agree with Lawrence that this approach has found less favor with the ICJ. Interestingly, after UNCLOS tribunals started using this approach of characterizing the subject matter of disputes, the court started in its judgments having a section at the start of its judgments where it determined for itself the subject matter of disputes. But in substance, what the court did was identify the claims that the parties were opposed on. The ICJ does not really adopt this approach that UNCLOS tribunals have of determining where the real weight or the true dispute lies. And if you accept, or assuming for the purposes of my presentation that you accept that a court or tribunal exercising jurisdiction under a compromissory clause is to assess its jurisdiction based on the opposed claims made before it, my next contention is that it's possible to identify certain types of claims that concern the interpretation or application of a treaty, which can be adjudicated under a compromissory clause. So To give an example, one of these types of claims is a claim that an obligation under the relevant treaty has been breached. So the argument is, if you make one of these types of claims, such as a claim that an obligation under the treaty has been breached, and that claim is opposed by the respondent state, there is a dispute concerning the interpretation or application of that treaty that is within the court's jurisdiction, regardless of whether the dispute also involves questions under external rules, and even if it does involve questions under external rules. So in summary, the argument is that when a tribunal is determining its jurisdiction under a compromissory clause, it should look at the opposed claims made before that. And that there are certain types of claims, such as a claim of breach, that if it is opposed, necessarily will mean there is a dispute concerning the interpretation or application of the relevant treaty, which is within the court or tribunal's jurisdiction. So that's jurisdiction, and that does not tell us necessarily whether or not the court or tribunal can determine external issues when exercising jurisdiction over the relevant dispute. And to answer that question, we need to turn to applicable law. So if a court or tribunal were to find that there is a dispute within its jurisdiction under a compromissory clause, the next question for the court or tribunal to consider would be, what rules can it apply in determining that dispute? Now, it's uncontroversial that when a dispute is brought before a court or tribunal pursuant to a compromissory clause, the court or tribunal can apply the rules in the treaty itself. It's also well established that courts and tribunals can apply some external rules. So first, courts and tribunals can certainly apply secondary rules of international law, such as the rules of state responsibility, the rules of the law of treaties. Second, it's also clear that courts and tribunals can apply external rules that are referred to in the treaty that gives them jurisdiction. And thirdly, pursuant to Article 31(3)(c) of the VCLT, courts and tribunals can also apply external rules to interpret the treaty over which they have jurisdiction. But again, it's important to be clear here that Article 31(3)(c) really has a quite limited scope. All that it empowers a court or tribunal to do is use external rules to interpret the treaty in question. It doesn't give the court or tribunal license to apply external rules more generally. And so these three well-established categories of external rules that courts and tribunals can apply are really quite narrow. So secondary rules referred to in the treaty itself, and rules that it's necessary to refer to interpret the treaty in question. And there are many situations, such as the examples that Lawrence has mentioned and the examples that I gave at the outset, where a court or tribunal is asked to apply rules beyond those well-established categories. And what I argue is that once a court or tribunal has determined that there is a claim within its jurisdiction, it is not limited to just applying those well-established categories of external rules. Rather, the court or tribunal can apply any external rule that it needs to apply in order to rule on the claim within its jurisdiction. So expressed in other terms, a court or tribunal can incidentally determine issues under external rules if it's necessary for the court or tribunal to fulfill its jurisdictional mandate and rule on the claim within its jurisdiction. And as I said, I acknowledge that I take a broader view of compromissory clauses than some others do. However, there is jurisprudence to support this interpretation and also, or this approach rather, and this approach can be theoretically justified as being based in an implied power of international courts and tribunals and exercising jurisdiction under compromissory clauses. And also, I would say that while I do have an expansive view of compromissory clauses, at the same time, I acknowledge that there are limitations to the types of external issues that courts and tribunals can determine. And one limitation, for example, would be a limitation imposed by the doctrine of abusive right and abusive process. So to expand on that point, if, as it could be said that some claimants have done in the past, proceedings are brought with the aim of obtaining a determination on an external issue, such as an issue of sovereignty under a treaty that does not concern sovereignty, that claim could be characterized as an abuse of the right to submit a dispute to dispute settlement or an abusive process. Just to wrap up, I'd like to note two recent developments very briefly that relate to this topic. The first is that last year in the ICJ's judgment on preliminary objections in the Genocide Convention Ukraine-Russia case, the ICJ clearly held for the first time that a state, in that case Ukraine, seeking a declaration that it had not breached a treaty was a claim within the court's jurisdiction. And so that's one of these other types of claims that I would say that is, if it's opposed between the parties, there is necessarily a dispute concerning the interpretation or application of the relevant treaty, which is within jurisdiction. So it'll be interesting to see if we see more claims of this kind in cases in future. And the second more recent development is that, as I'm sure everyone is aware, last year we had ITLOS's advisory opinion on climate change, which drew a number of connections between UNCLOS and external rules relating to environmental law and climate law. And UNCLOS tribunals in recent years have been somewhat restrictive in their willingness to address external issues, primarily issues of sovereignty. And so it'll be interesting to see if we have contentious cases brought before UNCLOS tribunals concerning climate law, if there is a bit of a swing back in the approach of UNCLOS tribunals and their willingness to determine issues under external rules. I'll leave it there for now. Thanks very much, Craig.
Thank you very much, Callista, for those informative remarks, and we might revisit the interaction of internal and external rules in the context of advisory opinions later this morning. Turning now to Raphael and focusing on the distinction between jurisdiction and admissibility. Raphael, the floor is yours.
Thank you, Craig. So my presentation today is on the dichotomy between admissibility and jurisdiction. And that dichotomy, I think we can all accept, is rather uncontroversial when it comes to public international law, when it comes to international jurisprudence of international courts, tribunals on interstate disputes. It's uncontroversial in the ICJ, ITLOS, and perhaps even human rights courts as well. Where there is some controversy as to the utility of that dichotomy is on two different regimes, which I will talk more about, which is the first on investment treaty arbitration, which is between the state and a private party, and more controversial, the regime of international commercial arbitration purely between private parties. Now, before I go into those two more controversial regimes, I just want to give some backdrop as to the dichotomy, the origins and the ICJ's jurisprudence. I think essentially ICJ's jurisprudence is quite well established. There are usually two main phases to proceedings, the appeal stage, preliminary objections, and the merits. Exceptionally, perhaps there'll be a quantum or compensation stage as well, where there is a positive finding at the merits phase. Now, where the dichotomy comes into use is, of course, at the appeal stage, where for tactical reasons, states would raise as many preliminary objections as they can. Of course, jurisdictional objections are primarily targeted at the scope of the consent of state parties. And of course, usually it's targeted at a compromissory clause. That's where most disputes are brought about, at least in these days, whether dispute falls within the substantive jurisdiction of a particular treaty, rational material. Contrast that with objections premised on admissibility. Admissibility, I would say it's a broad catch-all umbrella. It's basically, how I would put it, it's a preliminary objection which is not jurisdictional in nature. There are many examples of admissibility objections, exhaustion of local remedies, objection as to the nationality of parties, or even the mootness of a dispute, whether there's an actual dispute. So admissibility objections are based on the ICJ's jurisprudence. It's quite broad, It's anything which is outside a jurisdictional challenge, but still considered at the preliminary objection phase. Now, the practical use of distinguishing between jurisdiction and admissibility is normally in terms of ordering of the issue. Because theoretically, the ICJ first has to consider whether it has jurisdiction to hear a particular case. And if it does decide it has jurisdiction, then the possible second threshold issue is that, is it competent to hear the claim before it? But there are some exceptional cases, I think, where the ICJ has actually determined a case on an admissibility point without even going into the jurisdictional objections. I think one case would be the Interhandle case. So the ordering of issues that appears more, it's not a strict rule, it's more of, I would say, of procedural efficiency. So I think that is where the ICJ's jurisprudence is concerned. Where there is controversy is whether that dichotomy can be brought into the sphere of investment treaty arbitration. And that is where there are mixed reception as to whether an issue is of jurisdiction and of admissibility. One common example is as to preconditions to submissions to arbitration. So many investment treaties have like waiting periods where submission of arbitration can only be made after 12 months, 18 months. The precondition to arbitration could also be some sort of a exhaustion of local remedies clause, where the dispute must first be litigated at the host state's national courts first. Only then after the investor fails in the national court of the state, only then you can bring it to within the investment treaty protection. Now, whether these preconditions to arbitration is jurisdictional or admissibility, tribunals are somewhat split. Some have said it's an issue of admissibility, some have said it's jurisdictional. A third school of thought is it doesn't matter at all. Another class of preliminary objection is the identity of investor. So in investment treaty arbitration, what is interesting is that the treaties are usually broadly drafted, where an investor can include the shareholder of a company, which is actually the subject of the measure that's being taken of the state. And that raises, that opens the floodgates of claims. And I think this is maybe partially to address a question that was raised on the issue of parallel proceedings. So in investor treaty arbitration, it is quite common when investor will bring a claim in the national court. That's one forum. Potentially can bring it under an arbitration clause, an international commercial arbitration. And then the third forum is under investment treaty against the whole state. So it's quite common to see cases of parallel proceedings. And investment treaty arbitral tribunals are quite cognizant of this tactical plays, investors trying to have 2-3 bites of cherry, and there's a bulk of jurisprudence where arbitral tribunals have found that these kind of attempts to litigate the same dispute claim twice, 3 times is an abuse of process, and the tribunal has actually dismissed it on the basis of inadmissibility. Now, where it becomes, and now maybe I should move on to the third, before I move on to the third part of my presentation is then, where the distinction between admissibility and jurisdiction becomes more significant is at the annulment phase. So if it's an exit arbitration, exit within the treaty itself has an annulment procedure. The losing party of an exit award can apply to annul the award. But of course, the grounds of annulment is fairly narrow. One of it is manifest lack of manifest excess of power. And this is where the distinction of jurisdiction and admissibility becomes more significant. They are losing parties, winning parties of an award, simply saying that you cannot annul an award on ground of admissibility as opposed to jurisdiction, because manifest lack of power is something which is jurisdictional in nature. So if the tribunal has decided on a point of admissibility, that is not a ground that is reviewable, that can be annulled by the tribunal, the second tribunal. And this is interesting because this is transposed to the third regime, which is international commercial arbitration. And this is where there are some concerns about the dichotomy. So essentially where we are left at this point of time, many of the common law courts, and that is in England, in Singapore, and Hong Kong, has leaned towards using this dichotomy to decide whether you can set aside an award or not. Because as we all know, aside from public policy, natural justice, one of the most common grounds of challenging an arbitral award, whether it's commercial or even an investment treaty award, is a jurisdictional challenge. So predictably, winning parties would say, no, you cannot challenge an award based on admissibility objections. And that is why the distinction becomes quite acute. So remember I talked about preconditions to arbitration. So in some commercial contracts, there are also that kind of a dispute mechanism clause, where before you can submit a dispute to arbitration, you have to go through certain steps. For example, mediation, or you have to attempt good faith negotiations for 60 days, 90 days. And courts in Hong Kong and UK have found, interestingly enough, that challenges to non-compliance of these preconditions to arbitration is not jurisdictional in nature. It is a challenge to admissibility. So therefore, a tribunal's decision of that the preconditions of a submission of arbitration, whether it has been met or not, is an issue of admissibility, and therefore it cannot be challenged at all. Now, I think arguably when we talk about preconditions to arbitration, one can argue it's jurisdictional in nature. And I think now going back to the ICJ's prudence. I think there is some, not to say conflicting decisions, because ultimately we look at the treaty text, we look at the compromissory clause, what's the language used. So I think there are some ICJ cases which have found preconditions to submission of a case to ICJ, which has not been complied. That is jurisdictional in nature, and non-compliance would defeat that claim. Whereas, in contrast, overwhelmingly, national courts have found that preconditions in an arbitration agreement is not jurisdictional in nature. It is one of admissibility. And therefore, a tribunal award which finds that it still can hear a case, even if the preconditions are not met, cannot be challenged because that's jurisdictional, because that is one of admissibility and not of jurisdiction. Now, there are some pushback towards the usage of this dichotomy in international commercial arbitration. Just two recent developments. One is a very recent High Court of Australia decision, where the majority essentially, well, not positively rejects the dichotomy, but didn't resort to the dichotomy, whereas the minority did. And this is the case of CBI Construction and Chevron Australia. The second contrarian view to this is found in the dissenting opinion in the Hong Kong, called the final appeal case of C&D. So I think this is quite interesting to see where we are now. The Superior Court of England have not weighed in yet. The Hong Kong Apex Courts and the Singapore Apex Court have weighed in, and they have positively found the dichotomy useful in determining whether an objection is reviewable or not. The High Court of Australia, as I've mentioned, has not adopted this dichotomy. So it will be interesting to see how the English Supreme Court will address this dichotomy when the time comes. I think that concludes my presentation. Thank you very much.
Thank you very much, Raphael. Appreciate your remarks. I neglected to thank Professor Lawrence Hill Cawthorne, who had to leave for another engagement. So apologize for not thanking him while he was still with us on the panel, but we're very grateful for his participation. Now I turn the floor over to Claudia.
Thank you very much, Craig. Thank you very much for the invitation to participate in this very interesting discussion. I'm going to bring here a little bit the perspective of the human rights lawyers. And so even if the topic of the presentations is preliminary objections, you know that if we had to categorize the approach followed by human rights courts, we would say that human rights courts overall have a very expansive approach. And therefore, even if there are states that are trying to challenge the jurisdiction of human rights courts, most of the times human rights courts find a way to assert jurisdiction. So it's difficult really to find examples where we could illustrate a little bit. I mean, we have the cases where the states challenge the jurisdiction of the court, but again, I think in most of the cases, the outcome is that the court assert jurisdiction. So I thought it would be more interesting to explore situations in which indeed the issue of consent, for example, if we think about the distinction that Ralph made in terms of jurisdiction and admissibility, we know that jurisdiction of international courts is based on the consent of states. So I thought it would be interesting to see how human rights lawyers and sometimes states find ways to disguise their claims in a way that they could indeed find a resolution to the matter, regardless of the consent of the state to participate in the particular discussion. And I thought that a very good example would be to illustrate this discussion is by looking into the advisory opinion jurisdiction of the Inter-American Court. And I want to cover a little bit the Inter-American Court because it's the system that I know the best, but also because some of the cases that some of the advisory opinions that I'm going to mention relate to the US. That, as you know, the US is not a state party to the American Convention on Human Rights, even if it is a state party to the Organization of American States. And because of the particular nature and the broad nature of the jurisdiction of the Inter-American Court to issue advisory opinions, if we compare to the European Court, for example, some of the outcomes of these opinions have indeed involved, by implication, the US. But before I go there, I want to mention a little bit how it works. So for those who are not familiar, they can follow my illustration on the advisory opinions. The advisory opinion jurisdiction in the Inter-American Court is based in Article 64 that pretty much provides the member states of the Organization of American States, and this is very important, and certain organs of the organization within their sphere of competence may consult the court on the interpretation of the American Convention or of other international treaties concerning the protection of human rights in the Americas. When I say in the Americas, it's the Western Hemisphere, not the country. As you see, I try to underline two important aspects of this jurisdiction. Number one, that the opinions can be requested by all the member states of the OAS, not only the state parties to the American Convention. And number two, that the jurisdiction of the court applies not only to interpret the American Convention, which is natural, the tradition, for example, in the European system, but also other treaties that protect or concern, this is the language, the protection of human rights in the Americas. So the court has, in its practice, quite extensive practice on advisory opinion, has interpreted this clause very expansively. Number one, it has underlined that any member state of the OAS could indeed bring a request for an advisory opinion. And even if this has never happened, what has happened is that other states have brought requests that involve or implicate situations, human rights situations in states that have not ratified the American Convention, even if they are state parties to the Organization of American States. The court says that it envisions the advisory jurisdiction as an alternative judicial method to assist the states and organs to comply and apply human rights treaties within the organization, and that it considers this process as a multilateral process, non-litigious, where all states are invited to participate and represent their legitimate interest upon submission of a request by an OAS state party. So indeed, in the cases that in the advisory opinions that I'm going to describe, we have had situations of states, as I said, that have requested advisory opinions implicating states that are not parties to the OAS. But I also want to mention that the court has made a very expansive interpretation of what other treaties means beyond the language of the American Convention, and has concluded that this jurisdiction applies to interpret not only regional treaties, by any other treaty, even adopted outside the inter-American system, as long as it concerns human rights that affect one state party to the Organization of American States. So as long as we have one state from the Organization of American States that has ratified a treaty, then that treaty would concern the protection of human rights in the Americas. The other important thing that the court has decided is that it not only applies to human rights treaties per se, but also to provisions concerning human rights, even within treaties that are not human rights treaties. So this takes us to somewhat summarize a little bit and illustrate this assertive jurisdiction of the Inter-American Court, even in regard to states that have not ratified the American Convention. And the court has asserted this jurisdiction in regard to two situations. I would say states requesting the court to decide on matters that could affect the human rights situation in a state that has not ratified the American Convention, more clearly the US, or they have also requested the Inter-American Court to issue advisory opinions on a particular matter that they intend to litigate subsequently in an international court, or that they have already in litigation, even in another court that is not international, even in domestic courts. So this is how the advisory jurisdiction could affect situations that do not relate to consent. So I wanted to mention 3 advisory opinions that relate to the US. As I said, the US has not ratified the American Convention, but Mexico, in particular, you know that the relationship between Mexico and the US have always had some aspect of controversy, has brought 3 advisory opinions that somewhat involve human rights situations in the US. The first of those advisory opinion was advisory opinion 16, where the Mexico requested the Inter-American Court to determine whether there was a due process right to be informed as a detained foreign national by the host state of the obligation to notify the consular officials of the country of nationality of the foreign national, and at the same time to inform the foreign national of his or her right to seek assistance from those consular officials. The advisory opinion was requested on the basis of the American Convention, the ICCPR, International Covenant on Civil and Political Rights, the American Declaration, and the Vienna Convention on Consular Relations. That, as you know, is not necessarily a human rights treaty, but does have a provision, Article 36, that refers to this duty to notify foreign detained nationals of the right to contact their consular officials. Of course, when whenever you submit a request for an advisory opinion, the Inter-American Court expects that the state will provide a background, and the Mexico provided as a background that there were more than 50 Mexican nationals in the US who had been convicted to the death penalty, who had not enjoyed this right to be notified of the possibility to contacting the consular officials of Mexico, and Mexico had not been notified that there were all these individuals being tried for these very for crimes that could trigger the application of the death penalty. As I said, each time that you have an advisory opinion request, then all the states of the areas are invited to participate in the process, and in this one, the US did participate. The US claimed that the advisory opinion should not proceed, mostly because it was a contentious case in disguise. And indeed, had this been an interstate case, the Inter-American Court would not have jurisdiction because the US had not ratified the American Convention. The Inter-American Court decided that was not sufficient, that it was not indeed a disguised case, and ruled on the matter, and pretty much interpret and created a due process right under the American Convention in combination or interpreting Article 36 of the Vienna Convention on the law of on consular relations. As you probably know, this is something probably more well known by other international lawyers. Eventually, Mexico litigated a case before the ICJ where they tried to assert what they have indeed obtained as the legal claim, what they have, the interpretation that they have obtained by the Inter-American Court in the advisory opinion. Another interesting advisory opinion requested by Mexico concerned undocumented migrants, particularly workers. Again, Mexico framed the issue as a broader matter. However, they provided that they were concerned by the interpretation that certain states have done of their domestic laws regarding migrant workers. Everybody knew that indeed where Mexico was very concerned was about a decision by the US Supreme Court. That was a very famous decision, Hoffman Plastic Compounds, where the Supreme Court ruled that undocumented workers were not entitled to remedies for violations of their rights to unionize under domestic courts. So again, everybody, the background was that Mexico indeed was concerned about the Mexican nationals, a very extensive community who were working in the US and whose rights would not be protected. The US did not participate in this case, but the court concluded that states have a duty to respect workers' rights to equality and non-discrimination, despite their undocumented status, and provided some guidelines on the rights that they have to be respected. They based the decision on the OAS Charter, because the US is, again, a state party to the OAS, the ICCPR, but beyond that, they concluded that the right to equal protection and non-discrimination is a jus cogens norm, pretty much with the intention of suggesting that even if those states that have not ratified the American conventions were bound by this jus cogens norm not to discriminate against undocumented workers. The final advisory opinion that I want to mention, which is a very interesting one, and it's been pending as of today, concerns, it's an advisory opinion that was requested by Mexico and concerns the activities of private companies engaged in the firearms industry and their effects on human rights. I don't know if you are aware, there are some litigation, Mexico has brought some litigation in US domestic courts concerning the liability of these companies and challenging some of the standards that apply, particularly in regard to procedural immunity, etc. in US law. At the Inter-American Court, they request that the Inter-American Court discuss on the responsibility of private entities engaged on the manufacture, distribution, and sale of firearms and the relation to the violations of the protection of human rights. And also, they want to ask the Inter-American Court to decide whether states have an obligation to ensure a fair trial for the victims of these firearm commercial practices, which are carried out, again, in violation of human rights. Pretty much they're trying to get the Inter-American Court to say that the US domestic laws that grant procedural immunity to gun manufacturers could be in violations of international obligations. So this is pending, but again, it shows that through these advisory opinions, the Inter-American, Mexico has used the Inter-American Court to litigate in a disguised manner issues that concern human rights in the US. Another issue that I want to mention is that is very important in terms of human rights courts is the issue of overlapping cases, and I think that Rafa was mentioning parallel jurisdictions. And this issue concerns, at least in the Inter-American system, with a problem with the standing. The European Convention is less problematic because the Convention provides that persons can bring cases before the European Court, but the standing rule in the Inter-American system under the American Convention is that persons are only human beings. Therefore, only human beings can litigate before the Inter-American system. So, for example, and Rafa was mentioning arbitral courts. For example, whenever there are issues regarding the right to property, where some companies are claiming that the right to property is violated as a result of direct or indirect expropriation, issues that are traditionally litigated in arbitral tribunals. In the case of the European system, we see that indeed there are situations in which companies litigate in both the Human Rights Court and the arbitral tribunal. In the American system, that's not possible because the companies cannot litigate before the Inter-American Court. However, particularly in some countries where the conflicts arising out of the expropriations come from conflicts with indigenous communities, we do have a lot of litigation of indigenous communities bringing the cases to the Inter-American Court. So now we have a number of cases where the Inter-American Court has ruled on the same facts and applied human rights law to decide issues where the companies cannot participate. And at the same time, we have cases where the arbitral tribunals have decided on expropriations and the right to property in proceedings where the indigenous communities cannot participate. So in the end, we have these parallel proceedings with courts that are overlapping in their decision-making, even in regard to facts that are the same, and even with victims that or with parties that can be indeed harmed without their right to participate in the other proceedings. Of course, in these cases, we always have one case when one party against which the cases are litigated, which is the state, which, to be honest, indeed, in the end, comes to a state having two different rulings with two different obligations that sometimes are very contradictory. So I want to point out to this because I think that the issue of standing and parallel proceedings and overlapping cases in human rights law is growing in importance. I know that I'm running out of time, so I'm going to finish here, but I'll be very happy to explain this a little bit more or to cover any issue that our participants have of concern regarding human rights court. Thank you.
Thank you very much, Claudia, for that interesting presentation. I just noticed that the name on the bottom of your screen is, in fact, my own, which is not a punishment I'd wish on my own worst enemy. So, Professor Claudia Martin, just to make sure you get the recognition you deserve. Well, first, let me thank all of the presenters this morning, afternoon or evening, as the case may be, for your very informative remarks. We're very grateful that you participated with us today. We do have a little bit of time left for questions from the attendees, which I will exercise the moderator's prerogative to pose to you all. So let's start first with Callista. Callista, a question from the audience. Do you think that the ICJ's clarifications on drawing the distinction between new legal arguments that the parties may advance in pleadings, including on external rules, as opposed to new claims not originally presented in the application, is by now sufficiently clear? And in particular, we can draw your attention to Cameroon, Nigeria, the Qatar UAE Surd case, where allegations of genocide between Ukraine and Russia. Any comments?
Thanks very much for the question, Vlad. When I saw that Vlad was in one of the attendees, I knew I would get a hard question. I'm very sorry, but this isn't an issue that I've looked at before. I just had a quick look at the recent allegations of genocide case on this point. And based on reading it just quickly now, I would say, no, it is not sufficiently clear what the test is. I don't know if the attendees could speak, but I'd be really keen to hear what Vlad's views are.
I'm not sure that they can, but we will certainly solicit his views afterward. Okay, well, let's in that case move onward to Raphael. You had said in cases involving challenges to investor state awards, domestic courts have overwhelmingly characterized preconditions to arbitration as going to admissibility rather than jurisdiction. In the cases that you referred to, were the domestic courts, presumably interpreting their relevant domestic legislation, applying what they understood to be the distinction between jurisdiction and admissibility under international law, or were they referring more to a domestic dichotomy?
Sure, thank you. So Sean, I think I'll answer the question in two parts. One is more of a clarification. So when it comes to preconditions to arbitration, whether it's an investor state or commercial arbitration, the overwhelming is in relation to commercial arbitration. So there's the Hong Kong Court of Final Appeal C&D, and there's one English High Court decision, which has found in international commercial arbitration that preconditions are admissibility, not jurisdiction. Interestingly enough, there is a Singapore Court of Appeal decision, Swiss Borough of Lesotho, which heard an investor state award, accepted that dichotomy, but was circumspect to recognize that exhaustion of local remedies, even though conventionally taught as an admissibility challenge in international law. In this case, because the exhaustion of local remedies is inbuilt within the text of the BIT itself, then the court actually conceded and say, oh, in this particular instance, because it's in the text of the arbitration agreement, therefore it is jurisdictional. Now, I think then to your question, why do the domestic courts do tend to accept the dichotomy, and the reason for this is they primarily rely on two sources. One is the writings of jurists, textbooks and articles. And I would say that the most influential writing on this is actually Jan Paulson's, article. I think you can Google it, but this dichotomy, the push towards accepting this dichotomy in investment treaty arbitration and international commercial arbitration, and even modern textbooks, actually, you can trace it back to Jan Paulson's article. It's actually a very interesting article. He poses very compelling arguments of why we should accept this dichotomy, even in arbitration. But I would say that the domestic courts, perhaps, when hearing this setting aside applications, they do not readily make the distinction between whether it's an investor state award or it's a commercial arbitration award, and whether that reception of that dichotomy should differ in these two classes of arbitration. So the court has not really made that distinction. And that's why we can assume that the domestic courts perhaps have not properly grasped the origins, the significance of dichotomy all the way back from the ICJ and the practice of international courts and tribunal. I hope that answered the question.
Very much so. So I'm going to pose a question to the three participants, but I'm going to refer back to a comment that Callista made in her presentation, or observation rather. I believe that it was unclosed tribunals have begun to self-ID the subject matter of a jurisdiction in a dispute at the outset of their opinions. And so the question I want to pose to each of you kind of goes to judicial economy and the interests, the self-interests of the court and tribunals that are deciding these disputes, particularly when they're brought under preliminary objections. So can we see, or do courts and tribunals kind of act in their own interest, act in principles of judicial economy? Of course, if a preliminary objection succeeds, then the proceeding as a whole is much shorter. If it doesn't succeed, then presumably the proceeding as a whole is elongated. So, courts, certainly standing courts that have busy dockets, as opposed to ad hoc tribunals, also have considerations of their workload. They might be attuned to how their pronouncements on preliminary objections affect other pending proceedings just as much as the parties do. So with respect to each of your presentations, can we see, or should we see, courts kind of acting in their self-interest as they respond to preliminary objections from the parties? I won't pick on anybody by asking you to go first, but welcome any observations on that point. Okay.
I have some observations, Craig. So in relation to the specific comment I made, and I suppose my presentation specifically, and the use of this characterization approach or determining the subject matter of disputes, for my part, I don't see that as part of an exercise of judicial economy, which I know isn't what you were suggesting. I see it more as the court or tribunal making some sort of a judgment about what types of issues it is and is not appropriate for the court or tribunal to determine in the particular proceedings under the particular treaty. So I think it is an aspect of the court or tribunal acting in their self-interest, as I think you say, but for a different reason other than reasons of judicial economy. That was the only observation I had in relation to my topic. Thanks.
If I can say one thing, I would say that with human rights courts, that being regional, everybody wants to assert jurisdiction and apply the treaty. So I don't think that they're considering very much what the other courts are saying. The concern that they have, indeed, is that somebody else might decide a matter in a manner that they have, can influence later on the interpretation of that issue in the other regional system. And if I want to, if there is one thing that I would point out where we can see some distinctions in this regard is on climate change. I know that Calista mentioned the advisory opinion on by the International Tribunal of the Law of the Sea, but you know that there is a pending advisory opinion before the Inter-American Court on climate change and human rights, and it's the only advisory opinion particularly on human rights. Whatever the Inter-American Court says in this very expansive jurisdiction that it has, where it will apply pretty much everything under the earth on human rights, I think that, the Inter-American Court will set the tone in some aspects. And then, of course, that could, in the future, create some contradictions. I would say, for example, what the European Court might say. And if I can anticipate one issue, I know that we are going to have a clash between these two regional courts is the issue of extraterritorial application. So for everybody to think about it.
Thank you very much. Well, I think mentioning the clash might tee up a final question before we end the session, which again, it kind of goes to a technical point. So the question was, can disaggregated claims, so claims brought either piecemeal before a certain court or across different courts, could disaggregated claims brought by parties in different courts, or I guess the question is, can they be brought between different courts, which I think we agree the answer is yes. But how such parallel proceedings could interact or be stayed. So Claudia, I know in particular you mentioned an advisory opinion before the Inter-American Human Rights Court. There's also the subject of a case between ICJ and, of course, a very influential case between the U.S. Supreme Court as well. Of course, Calista, you spoke about disputes before the ICJ and other fora as well. Raphael touched on the part two. I guess it even invokes my question a moment ago, which is courts might be eager or might have an interest in finding jurisdiction if it exists, such that they could opine on the dispute rather than stay or punt the issue to somewhere else. So any observations, I guess, on how courts interact with parallel proceedings, whether they ought to defer, whether they ought to assume primary jurisdiction, or any thoughts on that? Great. Well,
I think that I already said pretty much what I think about human rights courts. They will not miss the opportunity. And again, I think that even in understanding that there must be some contradictory opinions in the end, I haven't seen yet the Inter-American Court or the European Court restraining itself from deciding on a matter that they feel is about the application of the treaty. Out of concern, they can set a standard that in the future might contradict, with a decision by another tribunal. I haven't seen it yet. Again, could be because traditionally these courts feel that as long as you frame the matter as a human right matter and it falls within the rights protected by the treaty, then they should have jurisdiction to decide on that. But I'm sure that it's different with other international courts that have different interests and they have different political considerations as well.
Yes, well, very well said. It's a matter of characterization, and given the opportunity, they will seize the moment. So our session today is concluded. Let me once again thank ASIL for sponsoring, thank the International Courts and Tribunals Interest Group for this very fascinating series, which we're now halfway through, and thank our participants on the call today. This concludes the presentation.
Thank you very much.
Take care.